This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Well, are your lordships on 12?
Yes.
Yes, Malas. May I just, Malas, comments for the petitioners? Malas, of course, I want to, it's a much larger issue, but your lordships were told by the other side and your lordship put the question, Malas, the authority. Now, Malas, the All India Trinamool Congress Constitution in clause 12C and 12I authorizes a body known as the Working Committee to authorize in turn anybody to conduct such matters. That's in the Constitution 12C and 12I. My learned friends in the court will hand it over to your lordships in a moment. Pursuant to that authorization, the resolution passed and I believe signed by one Mr. Derek O'Brien authorizes the deponent and the filer of this petition in turn. That document will also be handed over in addition, although I'm told it is there in the record also. So I'll pause while Mr. Agrish Basu shows your lordship those constitutional, those clauses and that resolution.
But by that order,
And emails it to Mr. Raju. Now, Malas, there cannot be in this case, this should not and cannot be Mr. Raju's best point, is my humble submission, Malas. It's a far larger issue, so once your lordship sees these two, your lordship may want me to proceed further, which I want to do, but I'm just pausing for lordship to see these two.
I'll have to address my lords on these two issues, my lord. It still doesn't authorize the person to file. I'll point out from even the documents produced right now.
petitioners have been restrained by civil court, my lord. That order is of great bearing. I've just, my lord, I'll hand over a copy of the order. So it's not a good print. You are a room. Rito Bruto Banerjee. He's not a party. How does he? Yes, I've obtained an order restraining them from, my lord, acting
So
as
we are against this process. We are against a statutory body who has taken some action.
Please see the injunction, my lord, on my learned friends in personam.
Person who has committed contempt can't be heard, my lords. If that is so.
Exactly.
So, can we proceed in a more organized fashion after lordship sees those two documents? I will finish and Mr. Raju can reply.
If the civil proceeding order is there and if this petition is filed in breach of those proceedings, the petitioner is in contempt. Unless he purges himself of contempt, he can't be heard. I'll make those submissions, my lord.
It is 7 July. So anything done after that is in breach of order of court.
Even arguing today is in breach of the order of the civil court.
It appears that Mr. Raju has every other point to delay the matter except the merits.
No, I have points on the
every other point in the book so that I can't seek relief.
I will argue on the merits
three accounts.
But on jurisdiction, I am arguing on jurisdiction. Because you don't have an answer to jurisdiction, you are trying to.
So may I start? May I start now? Would my lords then allow me to permit me to?
He has to satisfy my lord that he is not committing contempt. Now look at let me make my submissions as far as the is concerned, my lord. Thereafter he may address my lords on merits. First, my lords, kindly have a look, my lords, at the authorization which is produced.
Yes.
Now kindly, it is undated. Why? Because that would be in violation of the court's order of 7th. The petition is filed on 7th. Therefore, deliberately undated. Kindly look at the authorization. Not after the 7th, my lord. I, Derek, so-and-so, being a member of the National Working Committee. He doesn't say I'm authorized by the Working Committee. He says I'm a member. So kindly, he doesn't say, do hereby nominate, depute, constitute, appoint, authorize Subhash Chakravarti, agent so-and-so to perform all acts in connection with any proceeding before the Honorable High Court of Calcutta or before any other court of law throughout the territory of India in connection with matters on behalf of All India Trinamool Congress. If this is an authorization given by a member who doesn't say in the authorization given by him, one that is authorized by the Working Committee.
Yes.
Now kindly have a look at the affidavit filed by the person, authorized person at page 46. It is filed on 10th of July 26, after the civil court's order, my lord. Now kindly have a look further, my lord, on those two clauses which my learned friend read from the from the Constitution, my lords.
Yes.
The National committee shall be the highest executive authority of All India Trinamool Congress, shall have the power to carry out policies and programs of the Trinamool Congress as approved by the AITC committee, shall be responsible for the AITC committee, it shall be the final authority in all matters regarding interpretation and application of provisions. Then, my lords, which was the clause that he referred to? C. D. The National Working Committee shall place before every meeting of the AITC a report of the proceedings of its previous meetings, also the agenda of business for the meeting, and shall allot time for non-official resolutions of which due notice shall be given by the members of AITC in accordance with the rules prescribed in this behalf. So where is it that the authorization given by the National Working Committee to Derek O'Brien?
I. And you go to the I.
I, my lords. Kindly have a look at I. To meet any special situation, the National Working Committee shall have the power to take such action in the interest of All India Trinamool Congress Party. Therefore, it's a National Working Committee, not a member, my lord. Not a member. National Working Committee has not given the authorization. And the National Working Committee has not given the authorization to Derek O'Brien. Where is it? Member of the, he's a member. Member is different from a working committee.
Now, may I just respond?
I'm not finished, Mr. Singhvi. Dr. Singhvi, I'm not finished. Therefore, the authorization, which is not an authorization given by the National Working Committee, is not an authorization in eye of law. Even the authorization of Derek O'Brien doesn't state the date. It doesn't state that he is authorized by the authority of the National Working Committee to give this letter of authority. Therefore, this petition is filed by an unauthorized person, no authority in the eye of law. Now, kindly have a look at post 7. There could not have been any authorization.
Yes.
If they affirmed on 10, filed thereafter, now the civil proceedings. Now, the 7th of July 26. Title suit number 965 of 26.
Yes.
Kindly come to the last page, my lords.
Yes.
Page number 8. Or after the operative portion of the order, my lords.
Yes.
The defendants and their men agents are hereby restrained from creating disturbance in the National Working Committee elected in the special session of 22nd June 26 constitutes the only lawful executive body authorized to administer the affairs of All India Trinamool Congress, along with the defendant, their agents, servants, estates, or any person claiming through them from representing themselves as office bearers of the party, and are also restrained from interfering with the administration of the party, issuing directions or appointments in the name of the party. Appointment in the name of the party. I am appointing you as an authorized person to file this petition is a bar of this term interview administration. Appointment in the name of dealing with party records, funds, bank accounts, or property. They're dealing with bank accounts. Their prayer is for bank accounts. They're restrained from dealing with the bank accounts. How can they approach this honorable court concealing this fact? Dealing with so-and-so and communicating with the constitutional statutory authorities on behalf of the party. More defendants and their men and agents from taking forceful possession of newly tenable power at so-and-so, so-and-so, so-and-so. So there is a court restraint order. Now these facts are suppressed from this honorable court. Kindly look at the petition, my lords. Suppressing the fact that he is restrained from filing the petition, suppressing the fact that there is an order of a civil court which is in force, restraining them from acting as authorized persons in taking steps, in having look at bank accounts, having operate bank accounts. They file this petition, keeping this court in the dark. Now, if the petition is filed on 10th of July, this order is on 7th of July. Therefore, he knows that there is a civil court order restraining him from taking action, yet he files it. Gross abuse of the process of court, contempt of the civil court order. Such a petitioner can't be heard on merits. Now, kindly have a look at the petition, my lords. Kindly have a look at it, but not a whisper about the civil court order.
Whether they are the party, they are the party.
Yes, it's not. I am the
party, sir. They are the parties.
Okay. I'll just take 1 minute before this.
You are the you know it.
I am petitioner number 1.
Here in this
Yes, the All India reason. 1 minute.
in this writ petition, you are the party.
I should be petitioner number 1, All India Trinamool Congress. Because
Let Mr. Raju finish. I'll answer. Mr. Raju finish.
This petition can't be heard. Unless the
Right.
purpose of contempt, this can't be
I'll
heard.
tell your lordship the reason. Read with the order of court. This is a
Mr.
order once, my lord. Last.
Mr. Chaudhary.
Yes, my lord.
Have you affirmed this petition?
No.
Petition has been filed by members of the National Working Committee.
I am authorized. I am the only person authorized to
This
file.
petition
Filed
filed by you.
against members of the working committee.
Then I have to deal with the argument made by Mr. Raju in the different
I have
way.
not yet completed, sir. I have not yet completed. What is the
Authorized
hurry?
petitioner number one.
Mr. Raju has not completed.
I'm sorry.
Raju complete. Yes,
I'm sorry.
Now, the civil proceedings are filed in the court of learned first civil judge, senior division, Alipur, by one Joey Biswas, Anirban Das, and Srirupa Mishra. It is filed against Mamta Banerjee, the defendant number one. Members of the National Working Committee are number two. And this is that body who authorized the petitioner, according to my learned friend. He read the constitution and says authorized by the National Working Committee. Member Derek O'Brien is a member. That member is restrained by civil order, which I read. Arup Roy, it's a Banerjee, so and so, so and so. Then fourth is All India Trinamool Congress is a respond number 4 at so and so, so and so. These are the defendants. So there's a civil court order restraining them from functioning, from authorizing anybody. How can they authorize the filing of the present writ petition? Therefore, on this ground alone, the petition goes. Therefore, the issue of maintainability may be decided first and thereafter on merits. But thereafter, letters on merits after Dr. Singhvi. If my lords are against me on the maintainability, then Dr. Singhvi may be given the opportunity to address on merits, to which I will reply. But I'm not running away from the merits.
On maintainability, please note, Malas. There is a narrower argument and there is a larger argument. First point, suppression. I have to understand, and I am not for the life of me able to understand, how is there suppression by me when I am unaware of and not a party in the first date not appearing in this so-called injunction? Mr. Raju's client himself admits it's an ex parte order. Where does the word suppression come from? I can't understand. Number one, there can't be suppression if I am not present through advocate. Number two is more serious. This order which is flashing around today is 7th of July. Ex parte order without advance copy to me, without notice, without my presence.
So what?
My learned friend himself and me were appearing right through before your lordship's, well as other learned single judge of your lordship's court, in the freeze matter, where the state police was the main respondent, represented through Mr. Tushar Mehta. Now, in that matter, the main order, interim order is passed on, please, you are very smart, 3rd of July, 2nd of July or 3rd of July. Where is the date?
9th of July.
No, that's the original order. You are very
We're contemplating 2nd of July.
2nd of July is the interim order. And 9th of July, a final order, a final interim order is passed. In 2nd of July, the learned judge says, I intend to consider granting interim order. On 9th of July, the final interim order is passed, which till date not been challenged. Now, my learned friends, far from me suppressing, are not realizing that they are suppressing from the whole world, including that learned judge, that on 9th, when you are passing an order and the matter is argued, not a whisper of this 7th July order.
ED was not a party there, sir.
Forget ED. This is not an ED order which is relevant. It is a inter-parties order. If this injunction is there, then now Mala's third point. I didn't interrupt you, Mr. Raju. The same petitioner as today is the petitioner in that matter. Is the same deponent. Does it require Mr. ED and Mr. Raju to go and point out to the court that in an inter-party civil suit there is an injunction? It's the same petitioner, same deponent.
Yes.
They keep it in their pocket. Along comes the ED and says, I am suppressing.
Yes.
Today, Malas, there is a supposed triple engine sarkar with 3 agencies on the side.
Yes.
The state police, central government all appear on the last day till the 9th and no whisper. And today the ED says, I am so independent that I know the order. My counterpart never produced it and I, that is the petitioner guilty of suppression. This is bizarre, Malas. Only object of Mr. Raju's client is to delay this matter, so I can't seek relief and my accounts remain frozen. Now that's Malas, the third point I made. Now the fourth point. Malas, for the fourth point, your lordship has to step back a little bit and see the larger picture. Malas, never before, never, and I say it on Malas, testing challenge, have a recognized political parties accounts, 9 of them, been frozen in this manner. 9. Now, Malas, they froze this while they are the opposing faction of the TMC, is yet to be recognized either as the TMC or as the symbol holding party by the EC. There is a statutory constitutional symbols order. Under that order, the EC has the jurisdiction. What is happening in the other matter and here is that first the state police and now Mr. Raju's client collaterally is getting them recognized de facto as the only TMC. Of course, it is not surprising that the three agencies, income tax, CBI and ED, are only too over-eager to recognize them. They are batting for them saying, look, why are you hearing the opposing faction? Now, there is no opposing faction. Today, the EC has not recognized them. They have to recognize their symbol. But earlier, the state police and now the ED de facto recognize them before the EC gives its verdict. Fifth point. These people, inverted commas, gentlemen and ladies, are Malads on, according to us, a proper interpretation of clause 4, which gives no exemption from defection. This 2/3 is completely a misleading test. There has to be a merger of two different political parties by the political party as a whole, and additionally 2/3 of the legislature party has to approve the political party's merger. Now, Malads, these people are subject to 10th schedule, which again both the state and the central speaker have yet to decide. There again, Mr. Raju and in the earlier case the state police are giving them advance certification of a clean sheet on defection. So on the one hand, the EC doesn't recognize this TMC as the true TMC. On the other hand, the speaker has not yet decided whether they are liable for defection, which is a constitutional taint and a constitutional sin. But Mr. Raju's client is over eager to recognize them as the sole oracle through whom the TMC can speak. Just like the state police in the other matter is the sole, recognize them as the sole oracle through whom they can speak. So this is short-circuiting two constitutional authorities which have not yet decided. Now, the sixth point. There is a direct order of your lordship's colleague, learned single judge, defreezing the accounts. Direct order. After the second, where he clearly records his intention to give an order, and before the 9th, when he gives the order, the ED, knowing the likelihood of an interim order, jumps in and on 7th freezes 3 of those 9 accounts, which on parity of reasoning all would be defreezed under the Justice Talukdar supervision. So clearly,
when the ED freeze the
7th, knowing in anticipation, learned judge is about to pass a 9th order.
How much amount? 9 accounts or 7 accounts?
No, 3. ED has done 3 accounts.
3 accounts.
All the 9 accounts, including these 3 accounts, were the subject matter of a state police freeze in the other matter. Now turn to that other order after noting down 3 dates for us.
Yes.
On 18th of June, this is a completely colorable excise mala fide. When agencies, government and independent investigation becomes blurred, all are one, then this happens. Now let's just see, 18th of June this year, just 4 dates for us, a complaint is filed. It is filed by the same MLA and it is the same complaint which is today in issue. Bear with me, this is astonishing. It is filed by the same MLA who, along with all the other people whom Mr. Raju's client is openly supporting, received 25 lakhs officially from these accounts themselves to fight the elections prior to May 2nd, 3rd. The party gave 25 lakhs to this very complainant and all his 83 colleagues or whatever the number was, many more actually, by check. At that time, this was kosher. There was nothing suspicious about this account when they took the money gleefully and gorged it and fought elections on it. On the 18th, this person, 15 days after the elections, as is true of all opportunists, files a complaint. On the same day, on 18th, an FIR is filed. The complaint is converted into an FIR I wish, fellows, the teeming millions of this country would have an FIR on the same day on a complaint and not have to trouble the 156 court or your lordship's courts to get a FIR registered. On 19th June, the second day, I'm sorry, look at the lightning speed, look at the malafide, look at the culpable exercise of power. My Lord Ballas doesn't look at the form, my Lordship looks at the substance. What is all this, Ballas? Authority, vakalatnama, suppression, don't hear the matter. You are crippling, Ballas, just note one thing on the side. It cripples 4 constitutional articles, if your Lordship allows a political party to be crippled by freezing of accounts. 19(1)(a), 19(1)(d),
Yes.
300(a), 300 capital A, and of course Article 14. If this is allowed, then this is a new phenomenon, invent it, never happened before. Then all political parties will be asked to run democracy as an opposition with 1.5 hands tied behind their neck and go into the field and fight elections with frozen accounts. Now, on 19th of June, on the FIR of 18th, the investigating officer directs the bank and the bank conveniently freezes it. One day. On 2nd of July, the learned judge records an intention to do the order. Kindly give out the 2nd July order. Don't waste my lord's time. Kindly hand it over. It's on page 70. 70. 70.
Para 4.
Just read one paragraph.
Para 4.
And perhaps the learned judge bona fide made a mistake. Because in these troubled times, these intentions should not be pre-expressed. Para 4 at page 71. Unwittingly, according to me, I may be wrong, the learned judge has invited the wrath of Mr. Raju's formidable client. At the motion stage, court is contemplating to pass an interim order subject to final hearing of the writ petition. Now is got it?
Yes, yes.
This is 2nd July.
Yes.
The impugned freezing of accounts by Mr. Raju, that is his client, obviously not him, happens on 7th of July, 5 days later.
Yes.
And now read the order of your lordship's companion learned single judge. 53.
59.
58.
59.
58, yes.
59.
Yes.
I won't show it. Now, this is the order after more than 3 days of arguments, and I had happened to personally assist the court. So, after vehement opposition of Mr. Tushar Mehta and Mr. Neeraj Kaul for the complainant, and my case in open court was that the police authorities were arguing more than the complainant. The state police was arguing more vociferously for continuation of freeze, represented by Mr. Mehta, than the complainant. Complainant was Mr. Neeraj Kaul. Now, just see, para 3 has my contentions noted. I will not read it. 3, 4, 5 are my contentions.
Yes.
And just see, I made also the point, that yes, this particular faction of the TMC, I'm using the word faction loosely, whom I represent, has lost. But in a democracy, don't forget the difference in vote share is 5%. The winner and the loser difference is 5%. It's recorded in para 3 at the last. In para 4, I pointed out the alacrity, the embarrassing alacrity of one day in which your entire political party's entire accounts are frozen, all 9.
Yes.
In para 5,
8 accounts. As per the para 4, 8 accounts of the ITC.
8 accounts. 8 accounts. Then Mr. Mehta is heard at great length in para 7, all the way to para 10. Mr. Kaul, who is the complainant, is heard from para 11. So it's a very detailed, considered order for the very same issue. And please remember, Mr. ED, who is a derivative consequential department, is on the same FIR.
Yes, sir.
There is no other FIR. He is now tracing money laundering with no other predicate offence, if I may call that word. Right. That's very important. That is why your lordship was entitled to give an interim order in continuity and in harmony. Then come to para 14, where the state police has the additional authority, the state through the AG. And then see the para 20. So this is very important. This case is nothing but a derivative of the same set of three facts: complaint, FIR, and freeze earlier. Now para 20. Having considered the respective submissions made on behalf of the parties and the supplementary affidavit as well as the report filed, court is required to examine at this stage whether petitioner 1 ought to be permitted to operate aforesaid 3 bank accounts, which were debit frozen by the dint of communication made by the investigating agency, as it is reflected from the letter of the concerned bank authority, which is at page 84. Then, one of the arguments I made, this applies today, very strongly, because your lordship is having the ED act on a basic complaint which is delightfully vague. Delightfully vague. If your lordship doesn't mind, this is now quoted in para 22, etc. But if your lordship doesn't mind digressing for 2 minutes to page 48. 48. Show me. If on this complaint, which is ultimately the rock bottom basis, the so-called predicate basis, and then I'll read the FIR in a minute. Give me the complaint.
51.
51, my apologies. Complaint is 51. This is the way if the entire country's political parties' accounts can be frozen. It has come to my, just see the first para. Has got that?
Yes.
This Das, Vishwanath Das, along with all the others, have received officially 25 lakhs from the same accounts. Used them without demur or protest. Fought elections, won or lost on them. And the judge notes that. Most respectfully submit the written information. Certain, kindly underline the words I am asking your lordships. Certain serious and credible inputs. Please underline this phrase. Then disclose a reasonable suspicion. Please underline this phrase. Then next line, involving the generation, routing and possible concealment of funds. Whereas Alice in Wonderland cannot give them competition for delightful vagueness. Now come to the next para. Knowledge through reliable circumstances and surrounding development that certain funds allegedly arising out of illegal activities, including misuse of influence, dishonest financial dealings, and suspected unlawful collection of money, may have been routed. In a criminal matter with the freezing, can your lordships, on this basis, all ruling parties in the centre and the state with friendly police forces can use this delightfully vague language and cripple democracy?
Yes.
Is there a single objective fact till now? None. Now come to next para. Although the complete details regarding the source of funds, identity of all persons involved, and the exact transactional chain are not presently within my direct knowledge. Fortunately, with delightful vagueness, there is delightful candor. He's candid. The circumstances indicate that the matter requires immediate and thorough investigation, and that leads to a letter by the police, the friendly police, to the bank.
Yes.
Then next page. On a prima facie assessment of the available information, the act suspected may attract provision of cheating, etc. And then next, again, may attract cheating, not a single ingredient, factual, only adjectives and the sections. Now, please come to the last para. In view of the seriousness of the matter and the involvement of suspected banking channels and electronic, it is most respectfully prayed that a FIR be registered. Normally, a police would throw this as vague and I would have to go to court to get FIR registered. Now come to page 48. I said so in the other learned judge, I'm saying it again, the North Indian colloquial saying is Sanya Bhay Kotwal. It used to be a phrase from Bihar, which was one time ruled by Bengal. When the Kotwal is your friend, why are you scared? What is the worry? Now this Kotwal at page 48, with amazing alacrity, in less than 1 day, does this. And this is the basis of Mr. Raju's predicate offence. There is nothing else. 18th of June, same date. Just note at the second or middle of the page. Turn the page. This is your lordship's first information report. Delightfully detailed. Delightfully. So-and-so submitted. Second line. A written complaint alleging that based on reliable info, it is just a copy, I will not read it to save your lordship's time. It's a copycat.
Yes.
When you copy vagueness, you get vagueness. When you copy imprecision and generality, you get that. Now, On this, just come to the direction to the bank to freeze. So what is the most coercive step a police force can take? On 19th June, that letter is in the file of the other matter. It is not here, perhaps. It should be here. It is there. Don't I've seen it. Don't just see.
That's the letter the bank to us.
Yes, the bank's letter. The bank says, I have got a direction from the police to freeze. Next day, please turn to give the page. Just.
That's not it.
No, I'm missing.
Lordship just say it's not here, it's in the other matter, plus note it. On 19th June, the HDFC Bank writes, I received, Lordship, take my word for it, it's in the other writ. I'll produce it here. Mr. Agrees, please produce it. The bank says, I have received an intimation from the police, I'm freezing you. Now come to back to the learned single judge order.
It's not.
Yes.
To the learned single judge again, the other learned single judge. Page 65, para 20.
23.
Yes. 20 he starts, fellas. Come to 22 for a second. He quotes the complaint because I had argued in detail about the delightful vagueness. So 22 is important. He quotes the complaint. In 23, on mere reading of such complaint, does my lord seen 22?
Yes.
Now 23. On mere reading of such complaint, prima facie, it appears that the same is omnibus without pinpointing particular incidents or transactions based on which these 3 bank accounts were illegally enriched. Apprehension is also expressed with a complaint that if prompt action is not taken, relevant electronic bank, etc. may be altered. Taking note of the complaint, prosecution was initiated, and the last 5 lines of para 24, in connection therewith, investigative agency directed the bank authority to debit freeze on 19th June. 25. From the facts alluded above, it appears the complaint was lodged on 18th June, based on which the FIR is drawn up at 6 p.m. on 18th June. As I said, Malas, may the nation be blessed by such alacrity in every case. And hurriedly on the next day, 19th of June, these 3 were debit frozen. This court has made an endeavor to find out the materials which were available before the concerned police authority leading to debit freezing. At this stage, court is unable to find particular materials which would have been the basis of taking such abrupt step. Issue needs further consideration. Court finds it germane to record that before declaration of results, R4 was a member of AITC, that's what is the complainant, the man who went to the police. And he also contested election, being a candidate of the party, was elected, certain documents are annexed. It appears that for contesting, R4 was allotted funds from these very bank accounts. Without raising demur, respondent utilized these funds on being elected, lodged, being part of the faction. However, arguments are advanced on behalf that R4 belongs to a faction and claim that faction is the actual party. Judge rightly notes my submission which I made. This issue is pending for consideration before ECR. Para 30, and your lordship is likewise not concerned, as the judge was not concerned in para 30. This court finds it that it is not necessary to expand the scope of the writ to find out which faction recognized group, issue to be decided by competent authority. Today, court is considering steps taken by the investigative agency on receipt of complaint. Concern is expressed if steps are not taken, taking note of the complaint, etc. may be altered. Therefore, Manas, ultimately, the operative portion is Mr. Talukdar comes at 30, whereas 34 is general to facilitate operation. Justice Talukdar retired comes on 35, and then Manas, he clarifies that we are not giving any opinion on who's the real. Now, Manas, it must be noted, is not recorded, that Mr. Kaul made a fervent plea that the rival faction should also be allowed to operate. Mr. Kaul in open court in front of everybody made a fervent repeated plea. The judge said, no, I'm not going to do it. Mr. Kaul then for the complainant made another fervent plea that let the learned Judge Justice Talukdar before releasing any money hear them. First is joint operation, rejected. Second is hear them, rejected. Now, Malas, Now, Malas, this is the basis of this. Please note, and I'm ending in 5 minutes for us. Mine is a jurisdictional challenge. My challenge is that there is no identification, no segregation, no quantification of POC. Your lordship has to have some detailing of how and when they find it to be POC. There is no attempt there. More importantly, this has a huge punitive effect. And 17(1)(a) of the PMLA, which is used to suggest to your lordship that I should go under the act to defreeze accounts, will not apply to a jurisdictional challenge as here. My lord, your lordship is the writ court. My lord hears writs of various kinds. It is well established that when I come to a jurisdictional challenge, alternative remedies are no bar. In a particular matter, your lordship may have a discretion not to entertain. Now here, where there is legal malice, there is amazing alacrity of an unholy kind. There is lack of jurisdiction. There is Article 14, 19(1)(a), 19(1)(d) and 300(a). There is level playing field, there is democracy, and there is basic structure. Please note my last three words, brothers. When a political party is frozen, it impinges on democracy itself, and that touches directly the basic structure. When these are the points, 17 capital 1A cannot be the remedy. Also, Malas, in the facts I've just given, 17(1)(a) has a condition precedent on the text.
Yes.
If your lordship just picks up 17(1)(a) of PMLA, it says reason to believe. Now, reason to believe has to be of the sudden freezing in July 2026, that is 7th July. The section opens with the phrase reason to believe. And the belief is to be recorded in writing. Now, I can record anything in writing. That is a reviewable belief. It can't be a make-believe belief recorded. My simple point here is that the facts produced by them or alleged by them relate to 2023 to 2026. Kindly hand over the note, Mr. Agris, just for 2 minutes and I'm ending. I'm now just spending 2 or 3 minutes on something which they are trying to confuse on. Just hand over the note, please. My note.
It's done.
Yeah. Now, your lordship sees, Balas, para 4 at page 10 of that note.
Can you give me a copy of the note, Dr. Singhvi?
Yeah, certainly. Please, give it to email to him immediately, please. Certainly. Please email immediately. Now, Malas, section 17 opens with reason to believe, bracket the reason for such belief to be recorded in writing. Malas, you can't first cripple me, paralyze me, and then say go to the tribunal. This is a constitutional matter. Now come to Malas. B, after the quotation B at page 11, small b. The freezing order merely reproduces allegations arising from the predicate FIR without disclosing any material. So reason to believe is not reflected anywhere. Then Malas, D, C also. No account-wise tracing, no amount-wise determination or rational nexus. The freezing order is a colorable exercise of power. This is very important. This is why I said, Malas, there can't be reason to believe. On July 7, 2026, the transactions relate principally to the period April 23 till some of them in June 2026. And he forms a reason to believe for sudden freezing. My para D, Malas. DI. My lord's got DI?
Yes.
So you suddenly start having a reasonable apprehension for things happening in these very accounts which you have now frozen from 2023 for the very same entities you believe are co-conspiring with me for money laundering. Double I. Yes. The single I is a false reason. It's a culpable legal malice reason. The true reason is number double I. That the Calcutta High Court was defreezing. So you said, let's find another way of freezing the same accounts. That's number double I. Then, Malas, there's another interesting thing, Malas. This, on the merits, Malas, they claim, and that, of course, it is now standard practice for all leakages to happen in the press to color the ground, that this relates to Carvel Aviation, monies to whom are paid, which are money laundering. Just spend 1 minute with me on para 7. First and foremost, if you assume that this is the aviation money laundered, para 7 at page 12 bottom, the agreement for the charter flight, political parties must use charter flights. Perhaps the party which runs the ED uses on a factor of multiplier of 100 times charter flights compared to what much poorer country cousins can use. 100 times. Now, this agreement of charter is 2022 January. The helicopter agreement is June 22. The charter agreement, third item, page 13, is January 23. And then there is another charter in March 25 because the elections are on. Every payment is made through banking channel and check.
Dr. Singh, 1 minute.
And Malas, 1 minute. Let me finish now. I'm
not arguing. My
No,
lord,
but
I'm
you'll-
called in the first court. I'll just go and come back. May I resume my arguments at 2:30, my lord, to 2:30. I'm called in the first court. My matter is reaching in the Supreme Court.
Yes, you can.
3 or 2.
I'll come after. Let my learned friend finish.
I'm
come
just finishing. I'm
after
just very well, very well. Now, my lords, just note this. So 4 dates my lord has got. Now the beauty of this case is these are my lords known notified rates, 2 lakh per flying hour, amount paid by check, and come to para B. Sorry, C. Made through banking channels under agreed contracts 3+ years away. And my lords, there is a blanket freezing. The amounts of these agreements are much below the amount frozen. My learned friend Mr. Datta will give a lordships. The amount frozen is more than double or 3 times the amount in issue in these contracts. The object is on the 2nd, having heard the learned judge, on the 7th to cripple a political party. Manas, please don't forget that West Bengal has one Guinness Book of Records distinction, which it should rather not have. Your lordship may not know of it. There's a Guinness Book of Records. There are many distinctions. Bengal is the land of Vivekananda, Aurobindo. But one distinction it would not like to have is the only place I know of on planet Earth where the principal recognized opposition by the Speaker of the Assembly 100% supports the ruling party in government. If that is the new understanding of democracy, well, it's an Alice in Wonderland redefinition of democracy. There is no country or state I know where the main opposition recognized is the opposition which officially supports the government. These are not general statements. These are, Manoj, the reality behind what your lordship should go as a judge. Your lordship is not concerned with just the face or the facade. I will end, Manoj, Mr. Datta may add a lot of things, Manoj, by saying, please look at the larger picture. Please don't allow this decimation of democracy and distortion of democracy in this manner. You may have won, I may have lost. Difference was 5%. That doesn't mean that my right to exist is obliterated. That does not mean that if I have to go for a rally, if I need water and chairs, if I have to do anything, you will do a blanket freeze and the amounts will be given, I repeat, by Mr. Datta or Mr. Agnish. Amounts of these alleged, which are totally official contracts, are more than, less than 1/3 or half of that which is frozen.
160
And I'm deeply obliged, Manoj. I'm deeply obliged.
And my lord, as per the banks, my lord, reporting the other matter,
160 is the investment expenditure
160 is the amount
expenditure
involved.
in the election.
No, in regard to my lord, I'll show you a lordship of the freezing order. Please have a look to my lord, page 54. This is the freezing order which is under challenge in this petition.
Well, one sentence I forgot. Well, that of course the civil suit and suppression I have answered. These are ways of getting yourself to be the TMC before the EC recognizes the speaker. Now, as far as the authorization is concerned, this matter can't be dismissed or not entertained on that authorization. Mr. Derek O'Brien is a known face of the party. Yes, it is he who is authorizing. It can't be said that he doesn't have the authority of the party. It's a different matter that the party is split now. But everybody knows that he speaks for the party. And there is no doubt that Mr. Datta can produce the same thing again, Manoj, by resolution of the party, because we are not, Manoj. Now look at the Manoj, the Abhimanyu Chakra. I have got an ex parte injunction against you that you can't have a meeting. Because you can't have a meeting, therefore, look at this angle, Manoj. You cannot authorize Derek O'Brien. If you can't authorize Derek O'Brien, he can't authorize this deponent. If you can't authorize the deponent, the learned judge should dismiss. But therefore, I should be remedialist when you go and attach my accounts. Well, is this some kind of a cat and mouse game we are playing, or we are flirting with democracy? Well, we are playing with democracy with fire. Obviously, if you go and get an ex parte injunction, but everybody knows. I'm sorry.
Bylaws 12I say that the National Working Committee shall have the power to take such action. So
correct, National
Derek O'Brien is the member of the last validly
Derek O'Brien is the member of the last validly constituted working committee.
Correct.
He has authorized this ban. Now, subsequently, 2 days ago or 4 days ago, you go and get an injunction ex parte. How do I come to your lordship? That means, Willis, it's a bootstraps argument. I can't come to your lordships.
Just to remind your lordship, Lord, it's just two sentences, sir. 12th June is the meeting which authorizes me. 12th June is considered by the civil court. Civil court says two things. Number one, you people are not entitled to represent AITC. Number two, Ritobroto Banerjee is the person to represent. And the order is directly on operation of bank account. So A, petitioner number one can only be represented by me. And number two,
Can the civil
Without
court,
going into the
yes, my lord.
constitution.
can the civil court can take the power of the ECB recognizing one of the group to be a member of the committee?
Yes, my lord, please.
Tell me.
That is virtually.
If
So
you
it's not a void order.
No, I am not asking, I am not going.
No, I understand.
You are
It's a legal
asking on
question.
that.
It's a legal question.
It's a legal question.
Legal question.
Because who is having the party is
Yes.
to be decided by the EC. If the civil court is decided, then what is the duty of the EC?
Lordship is also, Lord, also please consider that these are all registered societies and this is not within the exclusive, Lord, domain. This internal party
different thing.
administration is not, my Lord, EC.
They are not the
Internal,
please mind it, it
Yes.
is not the election.
no, it's not
It is not
election.
the election.
Absolutely.
It is not the election
No.
of the
So-
committee.
Correct.
It is
Correct.
not the it is the recognition of the committee.
It's, my Lord, internally.
Yes, internally
Internally.
recognition of the committee with regard to the majority.
Yes.
With regard
So
to the majority.
220 members came on 12th of June.
Whether
voted
the
me
civil
through
court-
and voted
the
him out.
civil court can take the jurisdiction of the schedule 10 of the constitution.
No, it's very possible, my Lord. This is the plaint, Lordship. There must be full disclosure before your Lordship. This is the plaint. On this plaint, my Lord, is the,
I will hear you. I will let
Yes.
Mr. Singhvi complete.
yes. I'm sorry, I shouldn't have
No,
interrupted.
Willis, I'm done. Your lordship is very kind and patient, Willis. I'm done. Kindly hear them, Willis.
Thank
Your lordship will, in fact, excuse my absence for a while. I'm deeply obliged. Very, very deeply obliged.
My Lord, I have also, my Lord,
Yes, but only one thing that which,
The freezing order?
yes, it's at page 54. So there is a press release. Kindly have a look to page 53, which is a press release. Nowadays, the ED does this press releases. In fact, there is a judgment of this court which says that these kinds of press releases during investigation should not be done, be that as it may. Please take page 53, Milord, the third paragraph. Investigation revealed that around 160 crore was transferred from AITC bank accounts to Carewell. But these are, Milord, the charter party agreements and its related entity, mostly between April 23 to June 26. It is further revealed that Messrs. So-and-so routed an amount of rupees so-and-so during 23 to 26 to another newly incorporated related entity for purchasing the aircraft and one chopper. An amount of rupees 112 was used for making the said purchases. It also revealed that an amount of USD so-and-so was arranged as an unsecured loan in the year 2023 from one Cayman Islands based on the entity to purchase the helicopter. 3 Embraer Legacy aircraft and etc. were subsequently rented out to AITC itself, even though they were purchased from the corpus of AITC. Thereafter, substantial amounts were transferred.
No, 600 aircraft and Augustus helicopters were subsequently rented out AITC itself. Even they have been purchased from the corpus of AITC.
Yes, well, what is being said is that money went from AITC's account to Cayman's account. With that, the aircraft were purchased.
Yes.
And subsequently, those aircrafts were rented out
To AITC.
to AITC. That is the allegation, but this does not, correspond to, the FIR based on which, or the predicate case based on which, this freezing order has been made or ECI has been registered. Now, please take the freezing order at page 54. But these are all through bank transactions. Please take the second paragraph. The instant case under PML is based on FIR number 94 dated 18/6/2026. Mr. Dr. Singhvi has placed this complaint registered by Bidhannagar etc. on the basis of a written complaint by Vishwanath Das alleging dishonest financial dealings, unlawful collection of money and routing of suspected funds through bank accounts of AITC maintained at so-and-so. During the course of search and on the basis of materials gathered during investigation, it reveals that HDFC Bank bearing account numbers etc. which were also mentioned in the complaint which forms the integral part of the FIR has been used for processes and activities relating to acquiring and routing of the funds and using them for purposes which appear to be siphoning of the said funds by the persons authorized to operate the bank accounts as well as having control over the accounts. The same is also corroborated by transfer of funds of 133.84 crores approximately from AITC HDFC bank account number so and so to Carewell, which appears to have been incorporated for the purpose of diversion of funds from AITC accounts. A significant amount out of these 133 crores have been layered into a newly incorporated company, Carewell Flyjet, so and so, for purchasing an aircraft, etc., and one chopper. It also reveals that an amount of USD 1.7.
These are the allegations.
These are the allegations. But what is very important is, as your lordships know, my lord, the amount is at the most 160 crores. And if the bank has filed a report in the other matter before the coordinate bench, which is around 460 odd crores. Total what? Total cover. 426 and over here is 13. So 439 or 440, round about 440. And 200 crores FD. Now, first is the figure. This relates to 160 crores, therefore there can be no purpose in Milord freezing all my accounts and the entire money. Number one. Number two, which is a legal issue, is Milord, you need a predicate case to initiate an ECIR. The predicate case is based on suspicion that there may be some dealings, misdealings, etc., without any precision, without any specifics. Now, the ED brings out, Milord, this Carewell issue, which in my very respectful submission is not backed by any predicate case. In other words, the ED today is playing the role of a police in Milord investigating the Carewell issue. They can't. But I can understand.
But Mr. Datta, already the one court has passed an order, you are allowing some of the accounts. So what further is required now?
But I would be respectfully, Milord, submitting.
What is the main prayer in the writ petition?
Yes, Milord, my main prayer is quashing. That is, Milord, at the final stage.
Quashing of the ECR.
Please take me page
ECIR.
42. Yes. First, prayer B is quashing of the ECIR.
Yes.
Then C is declaring the freezing orders as arbitrary.
Correct.
Then D is, Milord, magnanimous quashing again the freezing order. Then E, which has already been done, Milord, by the other court.
Correct.
But I need this order at E. At the interim stage, in tune with
the coordinate bench has passed an order with regard to same account.
same account.
So now you are not able to operate this with regard to
because of this freezing account.
Due to this freezing.
Because of this freezing.
And what has happened there? No challenge on that order.
As of now, we have not been informed of any challenge. Yes. So therefore, Milord, this freezing order.
So you are now asking for this 3 account which has already been allowed by the court.
The same order.
Okay.
In respect of the same matter, same accounts, where the other coordinate bench has found that there is no materials because the coordinate bench, Milord, had invited a report. After perusing that, Milord, the observation of the court is that the court did not find any materials. Therefore, Milord, I am asking for, Milord.
No, he is not that. He is telling that the court has allowed the 3 account due to this, the CPR, due to the ECIR. Again, it has been freeze.
One thing is not.
Please take me page 60.
On their part. Order was passed on 9 and kindly see not where they got the notice from ED. The ED has freezed their account. Kindly see that. But they could have disclosed before the court. The ED has also freezed our account.
But state is not a party in this proceeding. I do not know what makes Mr. Mozumdar speak before the court. He's not he cannot be invited over here.
Why you are not mentioned?
No, we did not know that point of time.
Yes.
But unless and until the report is received from the police, how the the ED has acted upon?
No, that is
because the same FIR.
He on that spot, they can freeze.
No. ED kindly see the freezing report. The freezing is in connection with the same FIR.
Same FIR, but it is not our duty.
So if you are taking the plea of the suppression, he has not mentioned because the ED cases of the ED before the learned judge. So, but you are the authority, and on your FIR, the ED has initiated the proceeding.
What we
So
do, Lordship.
how the
It is not the duty of the ED to inform us.
not duty, but
May I assist your Lordship, Millard, on this point only, Millard, with Millard, what happens is, it is not, we have two options. One is under 65, if they share any information with us,
65.
they share any information. If they don't share, on our own accord, from newspaper reports or from any, if we find a scheduled offense in the FIR, we can pick it up and then we can start under section 3 only with regard to proceeds of crime, which was very well argued by Dr. Sanghvi on that particular day. Now, what my learned senior friend is arguing, my learned senior will amplify on that we are on proceeds of crime. Therefore, what is the main subject matter of the FIR? If there is any ancillary aspect with regard to proceeds of crime, we can also go over that. But that we'll argue later, Lordship. I will just on this aspect.
Okay.
I'm saying.
okay.
But Millard,
Millard, I think I'm also a serious impediment. Millard, at 2 o'clock, may I just,
Not be allowed.
Lordship just said 2 minutes?
Sorry, no. I am open court. I am telling I will not allow in the writ petition. There is some thing. You will be allowed if you come with the proper application. Let me hear the authorities, then I will.
Very well, Millard, I'll come with an
Your,
application.
your intention has brought to this notice of this court. The court will take note.